All rise. Support court with Judge Van der Bee is now in session. Judge's case number JVB2003, Morris case.
Thank you.
You're welcome.
You all may be seated. All right, Mr. Morris, you brought this case before the court. What's going on?
As the courtroom proceedings began, Mr. Adams took a steady breath and addressed the judge with a tone that balanced both frustration and hope. He explained that he is currently paying $880 each month in child support, on top of an additional $362 allocated specifically for the children's health insurance. But this wasn't just about numbers to him. It was about fairness, about involvement, and about a shifting situation that he felt needed to be reconsidered by the court. With calm resolve, he detailed how frequently he sees his children, making it clear that he's not some absentee father trying to dodge responsibility. According to Mr. Adams, he plays an active and consistent role in his children's lives, doing his part emotionally and financially. What's changed, however, is his ex-wife's plan to move to Florida, a move that he argues would drastically impact the existing arrangement. The judge listened intently, occasionally nodding while reviewing the payment records submitted by Mr. Adams' attorney. Mr. Adams continued, stating that the cost of living, the travel expenses required to maintain regular visitation if the relocation goes through, and the financial strain of the current support order all add up to something unsustainable. He wasn't trying to walk away from his responsibilities. He insisted. He simply wanted the court to recognize the reality of his situation and adjust the order to reflect the evolving family dynamics. This moment set the stage for a deeper, more emotional discussion around parenting, sacrifice, and the impact of long-distance co-parenting. The courtroom's attention sharpened, as everyone realized this wasn't just about money. It was about two parents trying to reshape their futures, each believing they had the best interests of the children at heart.
Well, I come to you today, Your Honor, because I'm trying to get my child support reduction.
Okay. All right. Based on what? Like, what's going on?
Well, I currently pay $880 a month for child support.
Okay.
I also pay $362 for health insurance. And I see my kids every maybe like 4 times a week.
Okay.
I see them pretty often. And she's trying to take my kids and move off to Florida.
Okay.
And, Your Honor, I'm not going for that.
All right. Did she tell you why she was trying to move to Florida?
Because she just want to live her best life.
She said that?
That's what it is. She want to go to the beach, drink coconut balls, whatever they have out there in Florida, and just have her best life.
Okay, wait a minute. So did she actually tell you that, or you interpreting her as living her best life?
Your Honor, why would anybody else want to move to Florida? That's Paradise City.
Well, I mean, I kind of want to move too, but I can't go.
You know what I'm saying?
Because I got to work. So could it be for a job?
You know, Your Honor, I haven't asked, because when she told me that she wanted to move to Florida, I got so upset about the fact of losing my kids that I was like, are you moving to Florida for like vacation time, or just so you can live your best life, or because we in Texas, I'm in Texas. I'm a good dad.
So what did she say to that when you said, are you trying to move to Florida to live your best life?
She said, yo, you shouldn't have messed up.
What did you do?
It's a long story, Your Honor. I could tell you how we split up, but I kind of messed up.
Well, I have time.
The tension in the courtroom thickened as Mr. Adams took a subtle jab at his ex-wife's motives. With a blend of skepticism and sarcasm, he told the judge that she was planning to move to Florida simply to, in his words, live her best life. It was clear he didn't fully believe her relocation had much to do with necessity, at least not at first glance. To him, it sounded more like a lifestyle upgrade than a career-driven decision, and he wanted the court to see it that way too. His tone suggested a deeper frustration, as if he felt left behind, financially burdened while she pursued sunshine and palm trees. But when pressed further, either by opposing counsel or the judge himself, Mr. Adams shifted his narrative slightly. Yes, he finally admitted she was moving for a job, and not just any job. She was reportedly pursuing a long-awaited opportunity to become a marine biologist. The courtroom seemed to take note of the subtle shift in tone. What had started as a casual dismissal of her motives as indulgent and selfish suddenly gained a layer of professional legitimacy. Still, Mr. Adams didn't fully let go of his suspicion. You could sense it in his phrasing, in the way he reluctantly acknowledged her career change, as if forced to concede a point he didn't want to lose. To him, it seemed like a convenient excuse wrapped in career ambition, a narrative that, in his view, masked a deeper disregard for the existing family structure. He argued that if she were truly prioritizing children's well-being, she wouldn't uproot them for a new job several states away. The courtroom remained divided. Was this a mother chasing a meaningful career, or someone seeking distance and freedom at the expense of co-parenting stability? That question would linger in the judge's mind as the hearing unfolded.
Do me a favor. I didn't even realize you had gum in your mouth till you start smiling. you know, I don't allow gum chewing in here.
I'm sorry, Your Honor.
Oh, it's okay. You can just put it to your back of your throat.
Yes,
I'm not
ma'am.
going to tell you to swallow it. I don't think that's really healthy.
Yes, ma'am.
But
It's
I
to the
have
back.
time for the story when you're ready, after you.
It's to the back right now, Your Honor. No more chewing for me.
Okay.
So,
Continue.
long story short, I met this lady our freshman year of college.
Okay.
And we were in class, and she was sitting in the front, I was sitting in the back. And I saw her, and I said, man, I'm gonna have to put my bid in as soon as class is over.
Bid, that's what they call it these
Yeah,
days. Okay.
we call it put your bid in. Because
All
you know, I'm
right.
sure there's other people that put their bid in too. So if I got the highest bid, of course I'm a getter, you know.
Oh, so
So-
you subcontracting these things now.
I was, yeah. At that time I was subcontracting, you know what I'm saying?
Interesting.
Right.
Keep going.
So I saw her in the hall and I came to her and my bid won. And we was together for years, Your Honor. We were together for years. We have 2 kids. We have a 5-year-old and a 10-year-old.
Okay.
Throughout the time, and as life just went on, we just started kind of fading, Your Honor. I'm a coach. I'm a football coach at a college.
Okay.
And one of the cheerleading coaches kept hitting on me. And I kept rejecting her.
So you put a bid on her too?
She put the bid on me, Your Honor. Yeah, she put the bid on me. So I gave in to that bid. She had a high bid. And at the time, my lady, she wasn't putting no more bids on me. She wasn't cooking me dinner. She wasn't massaging me like she used to. She wouldn't even let me watch sports on Sundays, Your Honor, because she wanted to watch The Bachelor. So it just wasn't working. And I gave in to what was going on, and I messed up. She saw my
At one particularly sharp moment in the hearing, the judge paused, his tone noticeably more stern, as he turned his attention to Mr. Adams' choice of words. Up until that point, Mr. Adams had been casually explaining his past relationship history and the circumstances surrounding the split, but it was a language he used that drew the court's disapproval. Referring to his romantic decisions, Mr. Adams described his past as putting in bids, a phrase that immediately raised eyebrows in the courtroom. What might have seemed like harmless slang outside the courtroom took on a completely different tone in front of the bench. The judge didn't let it slide. He leaned forward slightly and firmly rebuked Mr. Adams for what he perceived as an overly transactional and frankly disrespectful way of talking about intimate relationships, especially those that produce children. Comparing relationships to bidding in an auction wasn't just flippant. It suggested a mindset that treated human connection like a business deal. The judge made it clear that the court wasn't a place for vague street talk or casual phrasing. This was a legal setting that dealt with the future of real children, not a place for metaphors that commodified human emotions. The courtroom fell silent for a moment. Mr. Adams shifted in his seat, visibly uncomfortable, as the judge elaborated on the implications of his phrasing. If Mr. Adams viewed relationships as mere transactions, the judge implied, what did that say about his role as a father? Was his interest in co-parenting about love and commitment, or leverage and control? This wasn't just a semantic correction. It was a deeper call-out, aimed at the underlying values that seemed to surface in Mr. Adams' statements. The judge appeared to be signaling that any parent seeking relief or change in child support obligations would need to come from a place of genuine intention, not one of entitlement or bargaining. And in that moment, the tone of the entire proceeding shifted. The judge was no longer just evaluating finances and relocation plans. He was evaluating character.
phone. She saw that I was with her a few times, and she left me, Your Honor.
Okay.
She left me.
That was a very colorful story. It's very interesting. I hear the word bid. I think about someone, you know, trying to do construction on my home. So it's just interesting hearing you use that term referring to relationships. Okay, so you don't want her to move to Florida,
No, ma'am.
all right? And you want your child support reduced as a result if she does move? Or
Well,
do you just want it reduced just because?
I just want it reduced just because.
Okay, got it.
I feel like I know dudes that don't see their kids ever and they not on child support. I see my kids multiple times through the week and I'm paying $880 a month.
Okay. Fair enough. I believe I have majority of what I needed. Okay, is there anything else you wanted me to know before I move over to her?
No, that's about it, Your Honor. That's
Okay.
about it.
All right. All right. Ma'am, and give me your last name.
It's Adams with
Ad-
two D's.
Adams with 2 D's. Okay. All right. Mrs. Adams or Miss Adams.
Thank you.
Okay, Miss Adams. So tell me about, so this story that he told, he actually, you know, you won the bid or he won the bid.
Well, I think that tells you everything you need to know about his view of relationships is very transactional.
Oh, yeah. That's the word I was looking for. That's it. Transactional.
Yeah.
Okay.
It's very much I do this and you do that, and I think the fact that he didn't even bother to mention our children's names should tell you everything about our relationship.
Well, he told me the ages.
Yeah, well, that's great. Robert and Madison, that's with a Y.
But she ain't asked for the kid.
Okay, yeah, I get it. Anyway, so going back to, evidently I'm just going to Florida for a permanent vacation.
As Mr. Adams finished speaking, defending his reasons for seeking a reduction in child support, the judge turned to Ms. Adams for her response. Calm but clearly frustrated, she didn't waste any time in getting straight to the heart of what she felt was missing from her ex-husband's argument. Her voice didn't rise. She didn't need to shout. Her words were precise, measured, and deeply cutting. She pointed out something that may have gone unnoticed by the casual observer, but one said, hung heavily in the room. Not once during Mr. Adams' lengthy explanation did he refer to their children by name. To Ms. Adams, that omission wasn't simple oversight. It was revealing. She told the judge that this, to her, exposed the real issue. Mr. Adams' attitude toward fatherhood wasn't just casual. It was cavalier. It wasn't just about money or scheduling. It was about presence, about intention, about emotional involvement. Her tone conveyed that she wasn't just defending her position in a legal battle. She was defending the emotional well-being of their children. She explained that while he claimed to be a frequent and involved father, his words lacked the depth and warmth that would normally accompany such a claim. Where was the mention of their daughter's science fair project, or the bedtime routines, or the struggles with math homework? Instead, he talked in terms of time slots and payments. To her, it sounded more like a business arrangement than parenting. And the fact that he didn't say their names, that, she implied, spoke volumes. The judge listened intently, his eyes narrowing slightly as Ms. Adams continued. She emphasized that parenting isn't just about being physically present or making financial contributions. It's about recognizing and nurturing individual children with unique needs, names, and identities. And in her view, Mr. Adams had failed to show any of that in his testimony. Her response added a new emotional layer to the hearing. This wasn't just a disagreement about money or relocation. This was a deeper dispute about the nature of parenting itself. And her words left the court with a sobering reminder. Child support cases aren't just about the numbers. They're about the children whose lives are shaped by the outcome.
I'm actually going for a job.
All right.
So
what's that job?
Robert, and I'm going to be a marine biologist.
That's a
So
good job.
when this dream come apart? Because you ain't had this dream when we met.
See, exactly. Do you ever listen?
Miss Adams, Miss
sorry.
Adams, I need you to talk directly to me, okay?
Yes, ma'am.
And Mr. Morris, I've given you an opportunity to speak. Let me hear what she has to say.
You're right,
and
Judge,
people
I'm sorry.
can change dreams. I mean, depending on how long you guys have been apart, a lot could have changed in her life.
It's just she taking my kids, Judge. It's
Okay,
just-
well, let's hear what she has to say.
You're right, you're right.
She said marine biologist, right?
Yes.
That sounds like a really good job, and I want to hear about it. See how much money she makes.
She
all
just
right?
having random dreams, Judge, but it's all
Okay,
good.
that's great, but I need to see how much money she's making.
Right.
Okay.
I'm sorry.
All
Your
right.
Honor.
Yeah, less talking, more listening.
And you do the same thing. All right, now. Continue.
Jesus.
So I'm taking the kids to Florida because I have a greater job opportunity.
Okay.
And, you know, it's so interesting to me that he says that he sees the kids 4 times a week. I guess he's talking about maybe a FaceTime call or seeing them on his phone screen, because I certainly don't see him picking up the kids and taking them to the doctor and cleaning up vomit in the middle of the night. So it's great that he thinks that that he's paying for the right to see his kids, and that there are people who don't pay child support and who see their kids a whole lot, Judge. That tells you everything you need to know about the transactional nature of relationships. To Mr. Morris. So, look, the fact of the matter is, I guess he doesn't realize that his children are going to need to eat, whether they live in Texas or they live.
As the courtroom shifted its attention back to Ms. Adams, she adjusted in her seat and began to explain the financial realities that lay ahead if she were to relocate to Florida. Her tone was composed, but you could sense the underlying pressure of someone who had already done the math and felt the weight of it. This wasn't just a whim or a lifestyle change. This was a survival calculation. Looking directly at the judge, she calmly began to outline the cost of living increases she expected once she moved. In California, she had been managing to keep things afloat with a modest rental rate of around $2,000 for a 3-bedroom apartment. But in Florida, for that same space, something she insisted was necessary for raising her 2 children, she would now be looking at closer to $2,800 a month. That was an $800 jump before anything else was even added. But it didn't stop there. Florida, she noted, came with its own unique financial burdens. One of the most pressing, flood insurance. That's not optional, she told the court. It's mandatory if I want to protect a home for my children in a hurricane zone. The judge nodded slightly, acknowledging the logic, but also taking the growing list of expenses. Then came the everyday necessities, often invisible in courtroom conversations, but very real for any parent trying to raise children. Ms. Adams mentioned that both of her kids had developed sensitivities to certain foods, which meant she had to stick with mostly vegan and organic grocery options. I spend close to $800 a month just to make sure they're eating healthy, she said, her voice steady but firm. And that's before we factor in snacks, school lunches, or any special dietary needs. She continued, methodically listing utility bills that fluctuated with Florida's intense heat and humidity, air conditioning being a near constant expense. Add an internet service, a necessity for both work and school, and 2 phone plans to stay in contact with the kids when they're with their father, and the financial picture began to take shape. Not a lavish one, but a tight, calculated attempt to provide stability. Throughout her statement, Ms. Adams made sure to emphasize that these weren't luxuries. They were the new baseline for raising her children in a different state. She wasn't seeking more money out of spite or convenience. She was laying out the economic reality of being a single mother moving to a flood-prone state with 2 growing kids and a job in marine biology. Hardly the type of career one enters for money. As she wrapped up, there was a quiet pause in the room. Her words had painted a picture that was hard to argue with, one that put actual numbers to the daily challenges she faced, and one that reminded everyone watching that relocation isn't just about distance. It's about cost, consequence, and keeping your children afloat, literally and figuratively.
Live in Florida, and
That's true.
And they're gonna need new tennis shoes and new clothes, and I guess he just thinks that money goes on trees, or that kids just eat for free. It's not how it works. This isn't TGI Fridays. So the cost of living is gonna be higher in Florida.
All right, what are we looking at?
So my rent is going up from $2,000 a month to $2,800 a month.
Okay.
Because I have to have a 3-bedroom because Robert and Madison need their own bedrooms. And of course, I have to pay for flood insurance and other things like that.
Okay.
The judge, having listened intently to both parties volleying their arguments back and forth, took a moment to recalibrate the room's attention to one of the most critical and often misunderstood elements of these kinds of cases: the distinction between visitation and support. With his tone firm but not hostile, he leaned forward and addressed Mr. Adams directly, raising an eyebrow slightly as he prepared to unravel what he viewed as a common misconception. You mentioned, the judge began, flipping through his notes, that you see your children 4 times a week. He paused deliberately, giving weight to what was about to follow. But I want to clarify, when you say see, are we talking about physical presence, or are we referring to FaceTime calls and digital check-ins? Mr. Adams, momentarily caught off guard, hesitated, just enough of the courtroom to feel the tension thicken. It was clear the judge wasn't just asking for semantics. He was probing the foundation of Mr. Adams' justification for requesting a reduction in child support. The judge then elaborated. He explained that while virtual communication like FaceTime can play a supportive role in modern co-parenting, especially across distances, it doesn't replace the tangible responsibility and effort involved in actual physical visitation. Phone calls, video chats, even long texts filled with emojis, and I miss yous are no substitute for physically showing up, helping with homework, driving to school events, or cooking dinner during a weekend visit. In his view, conflating digital contact with hands-on parenting painted a misleading picture of involvement. He further noted that the official parenting schedule between Mr. Adams and Ms. Adams appeared to be inconsistent at best. There wasn't reliable rotation or documented agreement that confirmed this alleged 4 times a week claim. In fact, court records and testimony from both parties hinted at frequent last-minute changes, miscommunications, and a lack of enforcement. The judge pointed out that without a structured visitation plan, one upheld in practice, not just in theory, it was difficult to consider Mr. Adams' involvement steady or dependable enough to influence the child support discussion. Visitation, he emphasized, is not currency you exchange to reduce financial support. It's a right and a responsibility. But support is about ensuring the child's needs are met, whether or not you're there to witness it. His voice was calm, but unmistakably resolute. The implication was clear. Even if a parent maintains regular contact, especially through screens, it doesn't erase their financial obligation to provide, particularly when custodial parent is covering the brunt of day-to-day expenses. The courtroom remained silent as the judge's words hung in the air, landing heavily on both Mr. Adams and anyone in the audience still unsure where the legal system draws the line between presence and participation. And as he moved on to the next issue, it was evident the judge had made one thing unambiguously clear. Child support is not a reward for showing up. It's a requirement for helping your child live with dignity, stability, and care, regardless of how often you call or visit.
Right. And you mentioned food.
Yeah. So the kids eat organic
Okay.
and they're vegan. And so my grocery bill for them is already close to $800 a month.
Okay.
So his opinion that $880 is too much for the kids is wrong. It is a wrong opinion because your children deserve the nutrition they need to grow up big and healthy and strong so they can be college athletes like you want them to.
Okay, so Miss Adams, you said that your rent is going up $800.
Yeah.
You have to pay flood insurance. The children's diet, they eat organic food and they're vegan. Okay, so are you using the child support for flood insurance and rent too, or are you using it to feed the kids? I just want to make sure I'm clear on what it is that you're saying in regards to his request to get a reduction.
As the hearing progressed, the judge turned his focus to a crucial piece of the existing custody order, one that had seemingly been overlooked or, perhaps, quietly disregarded. With a calm but firm voice, he brought up the geographic restriction clause embedded within their parenting agreement. The original order, the judge reminded both parties, includes a clear stipulation. The children are to remain in Dallas County or one of the contiguous counties. This wasn't just a footnote. It was a legally binding term designed to ensure proximity between the parents, preserve stability for the children, and prevent either party from unilaterally altering the dynamic of shared custody by relocating too far away. Yet, according to records in the judge's own words, Mr. Adams had done precisely that. He had moved outside of the restricted geographic zone, without filing any formal motion to modify the order. The judge's tone sharpened as he emphasized the significance of this oversight. Mr. Adams, he said, glancing down the documents, if you wanted to change the terms of the geographic restriction, the law requires you petition the court for a modification. You don't simply pack your bags and assume the rules adjust to your circumstances. Mr. Adams sat quietly, knowing he had no rebuttal for this one. His move might have made sense for personal or financial reasons, but the courtroom doesn't operate on informal logic. It operates on procedure, documentation, and due process. By failing to formally request a change, Mr. Adams had not only violated the spirit of the original agreement, but had also created logistical complications for co-parenting, communication, and any future plans involving the children's residence. What made the judge's comments even more impactful was the subtext. This wasn't a scolding about a minor technicality. This was about accountability. When a parent moves outside the geographic boundaries set by a custody order without first consulting the court, it can disrupt everything, from school pickups to medical appointments, from weekend visits to emergency decisions. In the judge's eyes, such unilateral action undermines the very framework designed to protect the children's well-being and the co-parenting arrangement itself. The courtroom fell quiet as the weight of the oversight settled in. Mr. Adams had painted himself as a highly involved father seeking fairness and financial relief, but this moment exposed a flaw in that narrative. His decision to move, coupled with a failure to request a formal modification, suggests a level of impulsiveness, or at least negligence, that the court could not ignore. As the judge prepared to move on, his final words on the matter were deliberate. If you want the court to consider changes to custody, support, or location, you must come to us first, not after the fact. It was a stark reminder that in family court, intentions matter, but compliance with legal orders matters more.
Yes, Your Honor. So the thing is that if I was living in a one-bedroom because I was by myself, my rent would be a lot lower.
All right.
But I have to get a 3-bedroom because I have a boy and a girl, and I don't want them sleeping in the same bedroom.
Yeah, I can see that.
So I have to get a 3-bedroom, and so it's not just that, it's my electric bill, it's cell phones, because our 5-year-old has a cell phone, so now I have to make sure that we've got her a phone line so you can talk to her dad so he can see her 4 times a week on FaceTime.
So about that, he said that he sees the children now 4 times a week, and you're saying that's not true, except for like a FaceTime video or something like that.
He sees the kids on an inconsistent basis.
That's a lie, Your Honor.
Okay. So when you say inconsistent, right now, do you all operate under a standard order where it's like first, third, fifth?
He has every weekend, and I have during the week.
Okay, so every weekend he has.
Right.
Okay. During that every weekend, it's inconsistent, is what you're saying?
I mean, it's just...
As the hearing continued, attention shifted to Ms. Adams, and this time the spotlight was on her own misstep. Calm but visibly tense, she responded to the judge's inquiry about her planned relocation to Florida. Did she? The judge asked, ever file a formal motion requesting the court's permission to move with the children across state lines, as required by the standing custody order? Her answer was sheepish but honest. No, she hadn't. Instead, Ms. Adams admitted that she had relied on information she found through a simple Google search. She explained that based on what she read online, she believed that as a primary custodian, she had the discretion to relocate without prior court approval, especially if it was for a job. I thought I didn't need permission unless he objected, she said, referencing Mr. Adams. Her voice carried a mix of embarrassment and defensiveness, clearly aware of the implications. The judge did not let this pass quietly. With an edge of controlled frustration in his tone, he responded, Ms. Adams, Google is not a licensed attorney. He leaned forward slightly, his words deliberate and instructive. When it comes to legal custody and relocation, self-help legal advice is not sufficient. The law doesn't bend to what a search engine tells you. In that moment, the judge used her misjudgment as a teachable moment, one that many parents watching might learn from. He explained that court orders are not vague guidelines to interpret based on internet summaries or personal assumptions. They are precise, enforceable mandates that exist to protect both parents' rights and, most importantly, the children's stability. Any change, especially one as significant as moving across state lines, must be reviewed and approved by the court before it happens, not after plans are made and leases are signed. Ms. Adams looked down, processing the rebuke. Her intentions may have been practical, pursuing a better career, a better salary, and perhaps a fresh start, but intentions don't override procedure in a courtroom. What she thought was a harmless assumption was, in the judge's eyes, a serious lapse in judgment. She had essentially made a unilateral decision that could profoundly affect the children's connection to their father, school, and community. The judge's tone softened just slightly as he concluded the point, but the message remained clear. There are channels to do this the right way. Filing a motion, notifying the other parent, and letting the court decide. That's how we protect everyone involved, especially the kids. The gavel wasn't slammed, but the authority behind his words struck just as hard. It was a pivotal moment in the hearing, one that undercut Ms. Adams' earlier claims of being a more responsible parent. And while her move may still proceed under new terms, the court had made its position known. Google can't grant you permission to uproot your children. Only the court can.
Just all over the place. He just comes and goes and sees the kids whenever it's convenient to him, or maybe his girlfriend turns him down for a date or whatever.
Okay, so that was petty.
What girlfriend you talking about?
We didn't have to go there. We didn't have to go there. So is that what the issue is? You're still mad at him about that story that he told?
Well, okay, so he put in a bid for an upgrade, or the upgrade put in a bid for him or whatever, and now I have to explain to our son why our family fell apart.
Oh, so it's some hurt feelings there. Okay, I understand. So, have you already moved to Florida, or is this something that you're intending on doing pretty soon?
Well, I took the job offer and I've already found an
So
apartment.
the answer is yes. You pretty much already...
Everything but the U-Haul, Your Honor.
Okay. So in your court order, do you have a geographic restriction because Dad lives here?
Yes, but he...
After hours of testimony, tense exchanges, and detailed scrutiny of finances, parenting choices, and legal responsibilities, the judge finally leaned back in his chair, ready to deliver a decision that would reshape the trajectory of both parents' lives. The courtroom fell silent. This was the moment they had both been bracing for. Ms. Adams sat upright, hands clasped tightly in her lap, while Mr. Adams stared ahead, jaw clenched, anticipating the ruling that could either affirm his concerns or leave him reeling. The judge began with a measured tone, clearly aware of the weight behind each word. He acknowledged the complexity of the situation. A mother pursuing career growth out of state, a father who claimed deep involvement in his children's lives, and two parties locked in a tug-of-war between personal goals and parental duty. There were no perfect outcomes, only compromises. Then came the ruling. The court would allow Ms. Adams to relocate to Florida. The words landed like a gavel strike. Mr. Adams' expression shifted, eyes narrowing, lips tightening. He didn't speak, but his body language said enough. The judge explained that while Ms. Adams had failed to file for relocation properly, the court ultimately found her move to be legitimate and rooted in career advancement, not spite or escapism. Her new job in marine biology, though delayed in disclosure, was a credible opportunity with long-term stability for her and the children. But with that permission came a major condition, one that would directly affect Mr. Adams' financial obligations. If Ms. Adams chose to move, Mr. Adams' monthly child support payments, currently set at $880, would be terminated. The judge reasoned that since Mr. Adams would no longer have regular, in-person access to his children due to the increased distance, he would need resources to maintain visitation. That $880, once designated for daily child-rearing costs, could now be used by him to fly to Florida, book accommodations, or otherwise make meaningful visits possible. However, the judge was clear. The health insurance premiums, totaling $362 per month, would remain Mr. Adams' responsibility. This, he emphasized, directly supported the children's well-being and continuity of care, regardless of geography. The ruling struck a balance. It gave Ms. Adams a green light, to pursue her future, but not at the financial or emotional exclusion of the father. And it gave Mr. Adams a form of relief, but one that came with a new challenge: how to stay present in his children's lives from hundreds of miles away. The judge's voice carried no glee, no malice, just the steady authority of someone making the best call in an imperfect situation. "This is not a win or loss," he said. "This is about meeting the children's needs and ensuring that both parents remain involved in ways that reflect the reality of their choices." As he finalized the order, both parties remained silent. The tension had lifted. But what remained was the sobering realization that co-parenting across state lines is a different kind of battle, one fought with calendars, flights, and missed moments. Still, with the judge's ruling, a new chapter began, for better or worse.
Moved just outside of Ellis County, so he's just outside of the geographic restriction, so it's technically lifted, Your Honor.
Okay, and technically is what you said, but is that what your court order says?
Well, the court order says Dallas and contiguous counties, and he moved like a mile on the other side of the Ellis County line.
Okay, and I do have a copy of your court order here, and it doesn't mention that it's automatically lifted.
Oh, okay. Well, I was just thinking it was the one that.
O is right.
Thank you, Your Honor.
O
Thank
is
you.
right. What?
I'm sorry.
O is right, because you can't just leave. You can't just do that. You actually have to ask permission to modify this order like he did.
Well, can I modify the order to move to Florida?
Did you file anything for today?
I mean,
It's a yes or no.
No.
Okay. So you're moving without asking the court, can you move? And Dad is still living here.
Well, I guess I just didn't understand the way the order was written, because I had heard that if.
As the ruling came to a close, the judge wasn't finished. He understood that court orders can't predict every nuance of parenting, especially when distance and new routines enter the picture. So, before the gavel officially dropped, he addressed what might come next. His tone shifted slightly, not stern, but forward-looking, almost advisory. He acknowledged that life would continue to evolve, and with it, the possibility of further legal adjustments. Looking directly at Ms. Adams, the judge laid out a safeguard if she were to move to Florida, and if Mr. Adams failed to maintain meaningful contact with her children over an extended period. Specifically, if he demonstrated inconsistent visitation for 6 consecutive months, she would have the right to return to court and petition for the reinstatement of child support. It wasn't just a warning. It was a structured contingency plan. This clause acted like a pressure valve, giving Ms. Adams a legal mechanism to respond if Mr. Adams failed to follow through on his commitment to stay actively involved in her children's lives from afar. The judge made it clear. This wasn't a free pass for Mr. Adams to simply stop supporting his children under the assumption that his financial duty was gone with the Florida move. Instead, it was a flexible pause, a conditional break that depended heavily on his actions going forward. If he visited consistently, stayed engaged, and made the effort, the order would stand. If not, consequences would follow. Then, with the legal details out of the way, the judge took a more human tone. He reminded both parents that courtrooms can only do so much. Judges can issue rulings, sign orders, and enforce obligations, but successful co-parenting doesn't happen through paperwork alone. It takes conversation, compromise, and mutual respect. He strongly encouraged them to communicate with each other after the court proceedings, not through lawyers, not through passive-aggressive text messages, but through real, honest, adult conversations, for the sake of their children. The judge's final words weren't legalese. They were simple and deeply intentional. You two may not be together anymore, but your children are still watching how you treat each other. Let them see respect. Let them see effort. Let them see love, through action, not just biology. With that, the courtroom's tension slowly softened. The hearing was over, but the real work, the hard work of co-parenting across states, was just beginning. Both Ms. Adams and Mr. Adams walked out of that courtroom not with victory, but with responsibility. The next chapter of their family story will be written not by the court, but by the choices they make from here on out.
He moved outside of where it said, then I could move out.
Who did you hear that from? Did you Google? You did one of those Google searches? One of the Google lawyers told you that?
Yeah, I guess.
Oh, okay. Because they told you wrong, and that's the problem with Googling everything. You should have actually consulted with an attorney who would have interpreted this order properly to you. You can't just move. So let me tell you what we're going to do, because I think this is the fair thing to do. Regardless to whether you say his visits are inconsistent, he say they're consistent, The reality of it is when you move to Florida, he can no longer have access to those kids. So even if he were coming this day, and did every weekend, he won't be able to do that anymore now that you are going to move to Florida. So what I'm not going to touch is your custody arrangement. Not going to touch that at all. This is a child support court. That has nothing to do with us, okay? So I'm not going to touch it at all. You are free to move to Florida. However, he's coming off child support. So then he can use the money, the $880 or so that he would give you for child support. He can use that to travel to actually see the kids.
But what if he doesn't, Your Honor?
Well, if he doesn't, then after some time of him not doing it consistently, and when I say consistently and consecutively, it needs to at least be about 6 months or something like that, right? Then you can come back and let me know, Judge, he's not exercising regularly. I need some support for these 2 kids, right? But absent anything like that, I believe that's in the best interest of the children. And quite frankly, that's fair. You're moving without permission, right? Yeah. Which is a violation of your court order. So it's only fair that he stops paying child support. So beyond a reduction, he's coming off child support today. Now you will have to keep maintaining the health insurance, okay?
That's fine, Your Honor.
All right, so that, what is it, 362?
Yes, ma'am.
You'll still continue to pay the health insurance, but there will be no child support paid from him to you. Hopefully you guys can come to an agreement.
That's the plan, Your Honor. Once we leave, I plan on giving her a call so we could try to talk about things and kind of get on a good level with each other.
Yeah, I think that can work. And who knows, your job may transfer up here and you may end up being back in Dallas anyway. Now, if that happens, you all would need to come back, because then we need to look at something different about what child support is going to be. But until then, you know, enjoy Florida. All right, is there anything further?
No?
Thank you, Your Honor, for everything. You really made a big change in my life, and I'm glad we came to your court today.
All right, well, you're very welcome. And if there is nothing further, you all are dismissed.
Thank you.
You're welcome.